Hi, I'm Lindsay and I'm with High Sierra Legal, and today we're going to talk about wills. What exactly is a will? A will is a written, attested, which means sworn and witnessed, document which tells the court what you want to have done with your stuff when you pass away. And why I say the court instead of individual people is because with a will, your heirs will still have to go through the probate process, which we all want to try to avoid. I always say a will is a nice thing to have. It is the bare minimum that you should have because it does give the direction for the court and for your heirs through the probate process. It at least gives us some direction, because if you pass away and you do not have a will or a trust or any other estate planning documents, if you will, in place, then we have to kind of guess. Even with the will, sometimes we have to guess, even if they're super old, you've done them many, many years ago, you've had children since then. It's just our roadmap to follow through the probate process. So, what is included in a will? Many things are included in a will. The first one is stating that it is your actual will. Surprise, we want to make sure that we know that this is your actual will or your last will and testament, and that you are now stating your wishes of what you want to have done with your stuff. From there, we would like to list our items if we want to, but more importantly, we want to know who's going to make sure that those things are going to take care of, and that is what we call our executor. There are other items that should be included in the will, but those are the basic nuts and bolts of who you are, that you're forming a will, that you want the will to dispose of your items, who's going to make sure that that happens through the court process, through probate, and what we're going to do with those things. What are the different types of wills? So we have a most basic simple will, which is our last will and testament. We can have a joint will with a married couple. That is usually really frowned upon, and most states don't do those anymore. We can have a holographic will, which holographic means that it's handwritten. Those are also valid wills. Unfortunately, they're difficult sometimes. They can be easily challenged, but the court wants to follow your wishes. So why do we have to have these wishes delegated or written out for the court to follow? The reason for that is that society wants to protect dead people's things. So when you pass away, society wants to protect your things. So it locks down all of your assets, if you will. Bank accounts get locked out, investments, homes potentially, all of your assets get locked out because we want to make sure that your things just don't go to somebody that they're not supposed to. So you don't want to have somebody walk into the bank and say, I'm Sue Smith's daughter, I'm entitled to that $100,000 bank account. Yeeks, that's scary. So that's why we have the probate process. So the court, as a over governing body, if you will, of society, is going to say, hey, are you who you are that passed away? Is Sue Smith the person who she says she is? Is she entitled to your assets? Are other people entitled to your assets? So we want to make sure that there's a process for that. Also, you have debts. We want to make sure that our debts are paid for. Unfortunately, we're in America, and good luck, all your debts go with you when you die. So we want to make sure that those debts get paid for through your estate, that your assets go to who you want them to go to, and if you have underage children, that your children are taken care of through that process, that a guardian is appointed, or they're taken care of how you would want them to be taken care of. So what are the requirements for a will? So typically you need to be of an adult age, 18. You have the capacity to make sure that these distributions or your wishes are fulfilled, that you have the ability to contract that, if you will. So it's the same requirements as a contract, that you are of sound body and mind to make these decisions. So we do that because we don't want people to be unduly influenced or fraudulently told what to do. We want to make sure that this person is making these own decisions on their own will. What are some requirements for that will is that it needs to be witnessed and attested. So typically that means two witnesses will witness you sign your will in front of a notary, and it's called a double attestation, and it means that you have your two witnesses. So your first witness is witnessing you sign, and your second witness is witnessing the witness you. So that's always kind of fun, but it's important because it's showing that two independent people are witnessing that you are of sound mind and body, that you are signing your will, that this is your intention and these are your wishes, and that if there is an issue, we can bring those witnesses into the court and say, hey, is this person who they say they are? Is it their intention, that this was what they were signing, that they knew that this was what they were signing. There was no fraud or undue influence. They weren't weird. They weren't in some kind of form of incapacity, making sure that those wishes are exactly what that person wanted. In Nevada, the state that I'm in, there are other ways that you can make your will legal without that double attestation. You can have a self-proving will. You can have it just signed with the notary. The courts will interpret even handwritten documents, which is called a holographic will. So that means handwritten. Typically, there are requirements to prove that will. That's what probate is for, also, is to prove that will, to make sure that it is an actual valid will, and this is the most current will, if you will, and hasn't revoked any other wills. So there are other ways to validate this will, and a court wants to follow those wishes. So the court's going to try to do what they can to say, hey, these are your wishes. This is what this person wanted. Let's make sure that we follow those wishes as best as we can and as legally as we can. Many states, due to COVID or after COVID or before COVID, are allowing electronic wills. These are electronic signatures that are usually taking place through a electronic notary platform, if you will. Some courts will still interpret a typed document as a will. There are some requirements, obviously, to make sure that that will is accurate and proved to be the actual last document that this person wanted. So there are some requirements. So I would say check with your state, making sure. But the best way is to have it, drawn up by an attorney or a doc prep firm who does this. Such as us, we do these often to make sure that your will fulfills all the legal requirements to make it legal and binding upon your death. So what are some things that we like to include in our will? Again, like I said, we like to state that this is your will, that this is your last will and testament. This is who you are, that you are of sound mind and body, and you are creating this will to dispose of your assets. Other things that are important to add is how that will is going to be managed, if you will. And that's what we call our executor. And that is our quote unquote manager of our will. That's going to make sure that those wishes are fulfilled, that the probate process is fulfilled. And they're going to be the person who is going to advocate for you through that probate process to make sure that your wishes are fulfilled and followed according to your wishes and in your will. And then who's going to get your stuff? How do you want those assets to be distributed? So we like to have specific distributions. Typically, most people say, to my children, but we can run into problems with that because we want to make sure that those children are alive. Have they been born yet? Have you made this will 40 years ago and you've had 3 children since then and it's pretty nebulous? We want to make sure that it's pretty accurate and semi up to date, if you will, for your life. There is a term called per stirpes that is saying that your heirs or your children, and if your children are available, then it will go to their children. Typically, we'd have that language, which is kind of an all-encompassing language, or you would specifically say, I wish my estate to be split equally between my children. If one of my children should predecease, their share should go to their heirs by representation, so their children. And if my heir my child should pass away without children, then their share typically will revert back to the other children that I have. It's kind of an interesting concept, but it basically is an all-including language for that distribution to your children. Within our will, we also want to make specific distributions for personal property. Typically, that will be either included in the will itself or through a memorandum of personal property. These are things like our china set and our jewelry and artwork that don't have titles. Those personal items, guitars or, a grandfather clock or something that's very sentimental, that's typically what we'll put that into a personal property memorandum, which is informative and instructive for the executor to distribute those personal items to specific people that you have delegated there. An important note regarding children, that if you are in a blended family, you have stepchildren, those are technically, you might consider your children. You love them, you've raised them, that you consider them your, flesh and blood, if you will. However, in the eyes of the law, they are not. And so it's very important that if you wanted any kind of stepchildren to have a distribution, that you specifically name them. That if you put, I wish, my estate to go equally between my children, those stepchildren would be left out of that distribution. So it's important that if you are in a blended family to take that into consideration, that any distribution to a stepchild is specifically named for that distribution. So oftentimes, I personally prefer not to have that per stirpes language included because it is kind of nebulous. I like to very clearly delegate that, my estate shall be distributed equally between Bob Smith and Sue Smith, my 2 children. If Bob Smith or Sue Smith should predecease, their share shall be distributed to their children by right. If either Bob Smith or Sue Smith should predecease and do not have children, their share shall be distributed to the remainder of the 2 still living. That goes for same with your stepchildren, that you specifically name those people in there, because then it's not nebulous, it's not unclear. It is very clear that if a 4th grader read that, the 4th grader would know that Bob and Sue Smith are equally going to get this estate, and if one of them is not available, it'll go to their children, and if they don't have children, it's going to go to the remainder of the 2. There is no questionality about that. There's no formula. There's no trying to go through it and making sure that is what those wishes are going to be. It is clearly stated, and I like to be as clear and as transparent as possible in any kind of legal document, again, so that if I handed this to a 4th grade class, a 4th grade class would say, yep, there is no question about this. Another important distinction to include into your trust is if you have minor children, or not your trust, your will, sorry about that. So we'll go over trust later in a different video about why trusts are important and how they avoid this whole probate process. So in your will, if you have minor children at that point, who's going to take care of your kiddos if you're not available? Even if you have a spouse, obviously they're going to take care of those children if they're their biological children. However, sometimes that needs to be still named, that's going to be the guardian, that if either of you are not available, then who's going to take care of these children? Because the worst thing you want is your kids to have to go through some kind of guardian appointment through the court. That's kind of traumatizing, frankly. So it's nice to include that distribution of your children, in a sense, of who's going to then take care of them if you are no longer available and they are of underage. Also, how are your assets going to be taken into consideration to take care of your minor children for the life and raising that you would have done if you were with them? So that is also an important distinction of who's going to take care of your kids and how they're going to be taken care of if they are of underage. Another important thing to include in your will is if you have younger children, or if you have beneficiaries who may be young, that you don't want them to get a full amount all at once. So I always say, if you had a life insurance policy or you had quite a substantial amount of assets and you wanted to leave it to little Jimmy, who is 19 years old, and it's a $500,000 policy, well, then we're all getting a Lamborghini, frankly, because at 19 and you get a $500,000 check, yeah, probably going to blow it on something fun. So there are ways to put parameters into your estate planning or your will as to how those big assets are taken care of for beneficiaries who are a little bit younger. Those assets can be placed into a trust to hold for them until they reach a certain age. There can be parameters within that section of, upon 18, they get a certain percentage for school. Upon 25, they get a second percentage for additional education or for a down payment on a house. And upon 30, they'll get the full distribution. So you can kind of control these things, I always say, from beyond the grave, which is really kind of fun. That typically usually more happens within your trust and your trust estate planning there, but you can include that into a will that will then trigger a creation of a trust for that specific beneficiary only. Additional kind of wrap-up provisions in your will that you want to have is a no contest clause. So if somebody wants to challenge that, or little Jimmy is like, well, I should get 90% of this and my sister should get 10, well, then little Jimmy gets nothing, which is always kind of fun. I always like that parameter. I call it the Caddyshack clause, of that you'll get nothing and like it. You'll follow my wishes, and if you don't, now you get nothing. Other provisions in there are a bond requirement. So no bond is usually required, so you want to have that waived within that document, saying that your executor does not have to put up any money to manage this trust or this estate plan or this will. That is very important to put in there, so they're not having to go down to the court and put up, a couple $1,000s to manage this trust. So you want to waive that bond requirement. Also, simultaneous death clause. So what happens if a beneficiary and you happen to pass away at the same time? What is that triggering time frame? Is it within a day? Is it within 30 days? If they passed away within, say, 15 days of your death, does their distribution lapse and go back into the estate plan or into the will to be distributed as if they have predeceased? You can put those kind of parameters in there, and unfortunately these situations happen, and so kind of need to make sure that those are put in there so we can provide for any kind of contingency plan that may arise, because life happens, frankly. Another big one that we're seeing lately is how are animals being taken care of? They are part of our family. For me, they are my children. And so how are my animals going to be taken care of that if I'm not available to take care of them because I have passed away? So a lot of language involved in our wills and our estate planning of what happens to our critters and what kind of money is allocated to them, who do they go to, so ownership transfer, and what assets are being utilized to take care of our critters when we're not here, so for their lifetime and their benefit, to make sure that they're taken care of. You can specifically put parameters in there, you know, a one-time payment of X amount of dollars to, you know, Jane to take care of my 2 cats and my chickens and all of the critters I have or whatever, or you can do a percentage, who's going to take care of them. Sometimes that can also trigger, you can do an estate plan or a trust, if you will, just for your animals. It's a pet trust is what they're called, to make sure that our animals are taken care of how we would want them to be. And like I said, a will is kind of the bare minimum that we want to have. It's the very least that we should have, more easily followable. And finally, like we go back to the beginning, that we want to make sure that this is the bare minimum that we have, that we at least have a will so we have some direction of what you want to have done with your stuff through the probate process. Ultimately, we want to avoid probate because probate is a nightmare, and we'll go through what probate is in another video, or you can look that up in another video here or my blog post about what probate is and why we want to avoid it, because it is a long, lengthy process. Typically 8 months to a year is a fast probate. Assets get locked down like we talked about. The society wants to make sure that people aren't taking those assets, but with that, things still need to get paid for, like, you know, mortgages and bills. And I don't know about you, I can't cover 2 mortgages, frankly, until I would have access to that estate's money. And the courts are backed up a lot. It takes time to get in front of a court to get that authority to progress through that probate process. So I would say this is just the bare minimum that we have. At least it gives the wishes and it gives direction for the court and through the probate process, but there are other ways to avoid probate. One of those ways is forming an estate plan with a revocable living trust, which I love doing. Other ways are direct beneficiaries, but sometimes we can't avoid those direct beneficiaries on certain assets, but there are other ways to avoid probate. And so there are other formats to make sure that that happens, and we'll discuss those in other videos. And otherwise, you can check out my blog post or my website and for more information, or you can get a hold of me if you have any questions. And I'm Lindsay with High Sierra Legal. Thanks. So go ahead and follow me on Instagram or Facebook at High Sierra Legal, or check out my website at highsierralegal.com.